My name is Casey Halm. I'm with Davis Wright Tremaine. We're a national law firm with practices in Washington, D.C., San Francisco, Seattle, and a couple of other cities in the nation. We represent telecoms, cable, wireless, a wide variety of folks in the communications spectrum. And today I'm going to talk about intercarrier compensation issues before the Federal Communications Commission and potential implications for voice peering. I'm going to cheat and rely on my notes here. For those of you following the debate, you'll know that a major overhaul of the FCC intercarrier compensation regime remains unsettled and unfinished. Although the FCC has initiated several proceedings within the last 6 or 7 years with respect to unifying rates for certain types of traffic, dealing with questions of access charge reform and universal service funding, no major comprehensive reform to date has come out of those proceedings. Interestingly, though, within the last year or two, a number of proceedings have been initiated at the FCC focused on specific discrete issues falling within the intercarrier compensation rubric. At the same time, very recently, FCC Chairman Martin told the Federal Appeals Court in Washington, D.C. that he expected some type of intercarrier compensation reform within the next 6 months. So today I'm going to talk about what are some of these specific issues that we now see before the Commission, what will come of these proposals, if anything, and what implications there may be for peering. As you may know, there are several different forms of intercarrier compensation, 3 major forms that we generally think of today: access charges, reciprocal compensation, and universal service. Access charges and reciprocal compensation are a form of direct intercarrier compensation, usually tied to the termination of traffic to a local voice network. Universal service, on the other hand, is a form of indirect intercarrier compensation based upon revenues, contributions to the Universal Service Fund distributed to carriers, both competitive and incumbent, that operate in rural and high-cost areas. So a little bit about each of these different forms of compensation. Access charges, probably one that we speak of most often, quite a bit of developments recently and disputes over application of access charges. Generally speaking, access charges are associated with the termination and origination of charges for toll or long-distance traffic delivered to local telephone networks. A legacy compensation scheme that arose from the breakup of the Bell system, it remains with us today, despite its many problems. One significant issue with the current access charge regime is the fact that there are rate variances based upon several different factors, not only the jurisdictional nature of the call, whether or not it's interstate or intrastate, also the terminating leg. Rural telcos often have much higher terminating access rates than incumbent or BOC LECs. Competitive LECs are also another type of carrier that may have differential rates. Reciprocal compensation, transport and termination charges associated with the exchange of local traffic. This is the primary compensation regime associated with the emergence of local telephone competition arising out of Section 251 of the Communications Act. There are some rate variance issues with respect to reciprocal compensation as well. Voice traffic generally terminated at a higher rate than ISP-bound traffic. And significant disputes have arisen in the last 7, 8, 9, 10 years over what constitutes local traffic and is therefore subject to reciprocal compensation. Questions about ISP-bound traffic and virtual NXX traffic have largely driven that debate. Competitive carriers have argued largely that this traffic is local traffic subject to compensation. Incumbent carriers argue that it's something entirely different. Finally, the last leg of this three-tier system, universal service. Again, funding and subsidies for carriers, both incumbent and competitive, operating in high-cost and rural areas. A form of indirect carrier compensation in that revenues are driven through the federal universal service mechanism known as the Universal Service Administrative Company, or USAC, back through to carriers operating in rural high-cost areas. Subsidies are also made to providers that offer services to schools and libraries. Interestingly, all telecom carriers and interconnected VoIP providers currently pay into the Universal Service Fund, although not all receive subsidies from the fund. So, some of the recent actions at the FCC which have come up because the FCC has failed to act in a comprehensive manner include these 5 issues. Probably the most contentious issue, and that with the highest profile, is the application of access charges to voice traffic, specifically voice over internet protocol traffic. There's been quite a lot of debate about this concept of phantom traffic and whether or not there are obligations associated with call signaling parameters for carriers that terminate VoIP traffic. Another interesting debate that has come up within the last 6 months is the issue of traffic pumping, which is a question that has involved rural telecom companies fighting IXCs over particular traffic aggregation schemes. The Universal Service Fund is growing larger and larger every year. The FCC has recently announced plans to put a cap on certain components of the fund, which will, in an indirect way, affect intercarrier compensation. And finally, the current rate for ISP-bound traffic is technically an interim rate. The FCC long ago had said it would establish a permanent rate, but has yet to do so. So a little bit about each of these. There are a number of different proceedings right now at the FCC dealing with the question of whether or not access charges apply to VoIP traffic. Those that wish to impose that scheme upon VoIP traffic generally use the labels of access charge avoidance or arbitrage schemes. The basic question raised by several of these proceedings is whether or not access charges apply to IP to PSTN terminated voice traffic. Excuse me. A related issue is the question of phantom traffic. And again, this raises the question of what call signaling parameters must be included with VoIP calls terminated to local networks. These proceedings raise 3 major legal issues. First is the question of jurisdictional distinctions. Current intercarrier compensation regimes rely upon distinctions between the type of traffic carrier, the endpoints of the call, whether or not a call is local, long distance, intrastate, interstate, or international. Each one of those distinctions brings with it rate differentials and certain consequences with respect to termination of that traffic. Whether or not the FCC can deal with those larger questions is implicated by these 2 proceedings, by these 2 larger issues, and necessarily will require some action to unify those different jurisdictional questions. The second major legal issue is the question of what regulatory classification applies to telecom or VoIP traffic. Currently, pure voice traffic is subject to all forms of intercarrier compensation. Voice over IP, on the other hand, is not. The FCC has yet to define it as a telecom service under Title II of the Communications Act, and at the same time has not yet classified it as an information service, which would take it out of the Title II telecom regulatory obligations. Why the FCC hasn't definitively classified this is anybody's guess, but the implications are many, and that's another broad question that will need to be answered before any major intercarrier compensation reform is finished.